Good afternoon, everyone. Chris says that I have 15 minutes, so I'll take it. I'm here to talk about declarations of inconsistency as a technique in the protection of human rights. And it would be quite wrong not to acknowledge the presence today of one of the great architects of Part 1A, Margaret Wilson, who appointed me to the role when I first took it on, and whose work I think we are all indebted to you for, Margaret. 15 minutes on my topic feels a bit like that radio program where you had to speak for just a minute without hesitation, deviation or repetition. So I shall try to do that, but of necessity it's going to have to be a bit of an overview. When I was asked to write for today's presentation, I thought to write a reasonably straightforward and, I guess from my perspective, a reasonably predictable paper, encouraging the constitutional panel to think about adopting a wider declaration of inconsistency jurisdiction, and indeed possibly even one that would cover all of the rights in the New Zealand Bill of Rights Act. And that of itself seemed like a fairly innocent sort of a suggestion, but unfortunately while I was writing it I got significantly sidetracked by the budget night legislation and what the government has done to the parents as caregivers case. And so I simply couldn't resist getting stuck into that as well, and my paper as a result is a little bit of a mashup of those two things. I'm sorry when it comes out, but I'm going to try and explain the essential ideas. The first thing I want to do is to ask you, with a show of hands, who knows what I mean when I say, and Margaret, you're exempted from this, who knows what I mean when I say the Part 1A jurisdiction? Yeah, okay. So here we are, and I'm not being critical, of course, of anyone in the room, but here we are in the year 2013. There has been a jurisdiction vested in the Human Rights Review Tribunal for over 10 years now, which allows the tribunal, and on appeal the High Court and above, to declare primary legislation to be inconsistent with the right to freedom from discrimination. It is a right of fundamental constitutional significance, and no one knows about it. It is incredible to me how little this idea has gotten out there. And that is one of the reasons why I come along to these kinds of events and thump the tub a bit, because it does strike me as very unfortunate that after all these years people still don't know that we do have this ability to challenge government on policy issues, limited to the anti-discrimination right. So because of the answer I got, I'm going to tell you just a little bit about it. This is Part 1A 101, and it has to, of necessity, be very brief. But under the Human Rights Act as amended in 2001, the Human Rights Review Tribunal is given a jurisdiction to declare all public functions, that is to say the functions of governing, to be inconsistent with the right to freedom from discrimination in the New Zealand Bill of Rights Act. The amendments are found in the Human Rights Act, but it's a bit distracting because in fact they really affect what's in the New Zealand Bill of Rights Act. And I suspect, and Margaret will know this, but I suspect it had to be done that way because you can't really tinker with the New Zealand Bill of Rights Act that easily, but the Human Rights Act you could. The reason we have this series of provisions is because we had to have them. It wasn't a great government altruism that said, oh, it would be great if we could protect the anti-discrimination right in this way. We were confronted, and I'm sure you'll remember this very well, Darren, with what was called the sunset provisions, which effectively gave government a free pass on discrimination, notwithstanding its commitments under the International Covenant on Civil and Political Rights. And we had put that off, and something had to be done. A project was started called Consistency 2000s, which was going to look at all of our legislation and decide whether it was rights compliant or not, but that was a hopelessly ambitious task with respect. Partly because legislation always has to be understood in present day context, and so it was just an impossible job to say that you could look down on all legislation and say this passes and that doesn't. So instead, the idea was, back to ICCPR. ICCPR obliges member states not only to ensure that the laws they pass don't discriminate on grounds of sex and gender and all the rest of it, but also that individuals have an effective remedy, even where the discrimination takes place by someone in a public office. And that was why we've got Part 1A. We've got Part 1A because we had to have it in order to be consistent with our obligations under ICCPR. Hold that thought, because I'm going to come back to it when we talk about parents as caregivers. Just hold that thought. Now, the jurisdiction, in fact, is divided into two parts. One part deals with everything that's not primary legislation, and that's things like government policy. I mean, look, it could be the way a school is administered. It's all public functions, and it stretches very deep into our community. In that case, the tribunal has a very wide range of powers to declare inconsistency, to declare contracts to be illegal, to award damages, and to make other remedial orders. And Atkinson, which is the case about parents as caregivers, is a case like that. The other part of the jurisdiction is the jurisdiction that allows you to challenge primary legislation. And in that case, the only remedy that's available is a declaration. So the tribunal, and on the inevitable appeals, the subsequent courts can come along and say, what you've done here is inconsistent with the right to freedom from discrimination. And there's then a statutory consequence that the problem has got to be taken back to Parliament. And a report has got to be given to Parliament, and the government has to respond. Okay, that's the Part 1A jurisdiction in 2 minutes or less. It's, you know, you can imagine there are complicated aspects to it, but that's what we've got. Now, what I wanted to say about all of that was, first of all, that if it all sounds a bit sort of like rocket science or something that's unexpected, it shouldn't be. Because this is nothing more in relation to the anti-discrimination right than has been the case in the United Kingdom since they adopted the European Convention on Human Rights. They have exactly the same jurisdiction. It covers all of the rights in the European Convention, and the courts there, the higher courts there, have jurisdiction to declare incompatibility, and they do. And in my paper you'll find a website where you'll see that they make these declarations on a reasonably regular basis. So that's the first thing. This is not taking us out into any unusual or any foreign fields. This is just an idea which is already commonplace in the United Kingdom. And of course you know that in jurisdictions like Canada and the United States you have hard bills of rights, and so the problem doesn't quite emerge in that way. But certainly in the United Kingdom, the declaration of inconsistency function is now established. And just to give you an idea of the constitutional significance that was seen as attaching to that, here's a quote from Professor Klug, who wrote in 2003 of the United Kingdom amendments: the quest to re-establish appropriate boundaries between the judiciary and the executive and legislature drove the debate which preceded incorporation of the European Convention on Human Rights into United Kingdom law. There was a concern across the political spectrum and in judicial as well as academic circles that incorporating broad human rights standards into law would lead to the demise of the British system of parliamentary supremacy or sovereignty over the courts, without the transparency that preceded such constitutional earthquakes in other jurisdictions. And I'm only giving you that quote so that you get a sense of the way academics saw the impact of those changes in the United Kingdom. What's happened here in New Zealand is that the jurisdiction has been unnoticed, and I think it's because it was vested in a tribunal. I know why it was vested in a tribunal. I want to come back to that because I'm not criticising that. But I just pause to ask you to reflect, if this jurisdiction had been vested in the High Court, how much more would we all know about it? The academics would write about it endlessly. There would be conferences given over to it, and constitutional writers would say things like that about it. But they haven't. And the reason they haven't is because it's been invisible at the level of the judicial hierarchy in which it was placed. Instead, what you will find if you Google this sort of thing, or if you do research, is a great deal of research, of discussion about whether or not the High Court has an inherent power to declare inconsistency. And of course, that's across a much wider range of cases. And I mean, the one that always comes to mind is Hanson, Queen and Hanson, about deeming provisions in the criminal law relating to drug misuse. But you know, even if the High Court has that jurisdiction, which would have to be a self-appointed jurisdiction, because Parliament certainly hasn't handed it out, the question then is, so what? So what happens? You make the declaration. With respect to the tribunal's jurisdiction, you know exactly what happens. You write a report and it goes to government, and government's got to think about it. And that gives rise to this idea of a constitutional dialogue. That is to say, you've got Parliament makes a law, a set of circumstances emerge, and a problem comes to the tribunal. The tribunal looks at it and says, look, we think that that law is at odds with the right to freedom from discrimination. Have another think about it. And the government then has another think about it. And so the dialogue goes. So this is not a quick conversation, but it's in the form of a conversation. So that's what I mean when I say constitutional dialogue. Now, the question, I suppose, is, well, does it work? And I mean, you would expect me to say this, given that I had the role as chair of the tribunal for the first decade that these provisions were in force. But yes, it does if it's allowed to. And I don't really have time to go through the cases, but the case which, the one case in which a declaration of inconsistency has been made is a case called Howard. Mr. Howard had a gripe about the way in which the ACC legislation prevented him, as someone who was over 65, from being able to be considered for vocational rehabilitation when he'd had an accident. He said, well, hang on, just because I'm over 65, don't assume that I can't go back to work. And long story short, he represented himself in the tribunal and he got a declaration. What worries me, and this comes back to the theme, the point that I want to end on, what worried me a little bit about that was that even when we were hearing that case in the tribunal, it was clear that the government was going to change the law. There was really an element of mootness about it. It hadn't happened by the time the decision in the tribunal came out, but it was pretty clear that you know, broadly speaking, the law was going to change. And yet there was this extraordinary effort after the decision to overturn it. The Crown, the defendant, which was the ACC and Crown Law, commenced an appeal. It was out of time. They went to the High Court and the Court of Appeal on the question of whether or not they would be allowed leave to pursue the matter out of time. They were told no, they couldn't. And by the time they got to the Court of Appeal, the amending legislation had long since been passed. So what on earth was going on? How on earth could all of that effort have been justified? The rules had already been changed. I'm not sure what's going on there, but this is not the kind of behaviour which is consistent with an idea of constitutional dialogue that I talked about. Okay? Constitutional dialogue requires two parties who are listening to each other. And who are taking part in the discussion. And as I say, that has always worried me. So now I come to the question of parents as caregivers, and I have to disclose that I am the parent of a child who has profound complex special needs, so I have some skin in this game. But well, I suspect most people in this room know what happened. The tribunal decided that the Ministry of Health policies preventing the payment of parents and family members who act as caregivers for people who are disabled was discriminatory on the grounds of family status. That decision was found upheld in the High Court and in the Court of Appeal. So if you look at it in terms of that dialogue, you've got a set of provisions over here. They've gone to the tribunal, they've been tested, and the judicial branch, Tribunal, High Court, Court of Appeal, has said to the legislative branch, hang on, this isn't working, this is not consistent with the right to freedom from discrimination. And so what does the legislative branch do? On budget night, it puts through legislation which says this is how this case is going to end. Those people who are in this class can have this much money, and those people who aren't, well, they just aren't. And more than that, the tribunal, this is the jurisdiction that had been given in 2001, the tribunal and the courts may not inquire into it. Okay, so you've got the government in this constitutional dialogue saying what? I don't know how you characterise that. But it's not a very polite answer to the judicial analysis that's gone on. Now, why am I telling you all of that? I'm telling you all of that because when I started to write my paper, I wanted to simply say, with a shining face and great eagerness, the declaration of inconsistency jurisdiction is feasible, it works, it will add to the debate about human rights in New Zealand in a positive way, and it doesn't require you to decide that you've got to have a written constitution. All you have to do is decide that you're going to have a remedy, a process by which people contest the rights that are already in the Bill of Rights Act. And better than everything, I think, it means you don't have to solve the problem anymore, which is a political problem, about whether at one end you've got the government or parliament that's sovereign and supreme, or whether you're going to have, in some cases, judicial determinism as being, judicial determinations as being the ultimate decider of these kinds of issues. So it's not a challenge anymore between these two entities. It's a discussion. And it's a discussion which acknowledges that we make general propositions of law over here. In specific cases, they may not work out quite the way we planned, so we have another think about them. But ultimately, we leave it to the legislature, who, after all, does have ultimate responsibility for the allocation of resources, to try and fix the particular problem that we've identified. Look, the budget night legislation to the New Zealand health and disability legislation is not a good look for someone who wants to advance to the Constitutional Arrangement Panel the idea that they should introduce a declaration of inconsistency jurisdiction across the board. It is kind of disappointing. But still, I'm going to end by saying that I think that the Constitutional Arrangements Panel should think about an extended declaration of inconsistency jurisdiction. There are issues that I was going to talk about, but I don't think I've got time, about exactly what that looks like. I don't think you can leave it in a tribunal. I think you've got to put it somewhere higher in the system, because although the tribunal has worked well on an access to justice basis, I'm not absolutely sure that it's sufficiently high enough in the judicial hierarchy to be appropriate for those kinds of things. But I have gone on to say, well, maybe what we need is something like a constitutional court that could collect up and deal with these declaration of inconsistency issues. It might as well encompass Treaty of Waitangi issues. And as Chris so kindly pointed out when you read a draft of my paper, what about electoral issues? And you could have this group of experienced judges with what I would hope would be a set of procedural rules that would protect access to justice. And I'm going to say that I think that that's, although it may seem far-fetched, that's a far more likely positive outcome out of the current constitutional review process than actually getting a written Bill of Rights. Because I think I'm here to tell you that that's not going to happen. I couldn't help but, I hate to end on a gloomy note, but when the review started, there was a few people interviewed on Morning Report. Morning Report did a series of 4 sessions, and the first one they got in the Prime Minister and Andrew Geddes and Professor Philip Joseph and said, well, what's this all about? And to a person, they all said, oh, well, I don't think anything's really going to come out of it, but it'll be very interesting discussion. So, and that's probably right. I don't sense that there's a political mood in New Zealand for the enactment of a Supreme Bill of Rights. But this might work. This could actually be made to work, as long as government's willing to participate. That's all I have to say. Thanks.